Hello, everybody. This is Chris Addig with the Veterans Law Blog, and we are going live on Facebook today. Here it is Friday, November the 18th, 2016, and it's about 3 o'clock Central Time. You can see behind me the Little Rock skyline back there. It's getting pretty dark and pretty stormy here. So, as is often the case whenever there's a thunderstorm, we've got to worry about the power going out. I'm going to keep going. If the power goes out, this video will keep recording, hopefully. And we'll be able to air it. If not, we'll go ahead and reschedule. But anyway, welcome to the Veterans Law Blog Live. If you guys can hear okay, if you just give me a quick like or a thumbs up or something to make sure that the audio is coming through good, just let me know that. If you have any problems with the audio throughout the session, just go ahead and send me a message on Facebook. We'll see if we can adapt on the fly. So got about a 45-minute to hour-long show planned for you here. We're going to talk about some of the things going on in the news lately as it relates to veterans. We're going to talk about today's main topic, which is walking you through the general overview of the VA claims process start to finish. And then we're going to take some questions from veterans. I've got 3 really great questions from veterans that have been submitted over the last week or so. I filtered through probably several hundred questions that y'all asked. And I'm going to go ahead and put these 3 up there. If some questions come through during the course of this show, if I see them pop up in the comments section, if I'm able to answer them, then I certainly will do that. But we're going to focus on the 3 that we've picked from the list that y'all have submitted. So at the end of this show, just so you know, in the comment section, I'm going to post the show notes. And those show notes are going to include any of the links to the blog or other sites that I describe in this video. Any information that I share or tell you that it's going to be in the show notes, that's where you will look to find it. And so in the show notes, the first thing I'm going to tell you, there's going to be a link to where you can submit your questions for our Veterans Law Blog Friday live Facebook Q&A. I got to come up with a shorter name for it. That is really a mouthful. But in any event, I'm going to get you that link in the show notes. So without further ado, let's just jump right in. I want to tell you the Veterans Law Blog, my goal is to make the Veterans Law Blog the absolute best resource for veterans who are battling the VA. We have thousands of posts and thousands of videos on the blog that I've been building since 2007. And it teaches veterans how to improve their VA disability claims, to take back the power from the VA and cut through the fog that we all know the VA claims process to be. The Veterans Law Blog is member supported, and that means that it's very expensive to get this information out there, to post these videos, to share them, to host all this information, to publish the books that we share. And so in order to do that, we ask the veterans that use the blog support it through a membership. There are 2 types of memberships. There's a premium monthly membership and a premium annual membership, depending on what your budget is. You can choose either one of those membership levels. So I'm going to put the link in the show notes. I would encourage you to join the Veterans Law Blog. When you join, you get access to thousands of posts on the blog, all the posts and all of the video blog entries. You're going to get access to a searchable database by topic, by claim type, by medical condition. You're going to get priority customer support and priority questions answered if I can answer them. The only thing I don't answer is I don't provide legal advice through the blog, but I do my best to answer all the questions that are sent in. You're also going to get 15% discount on any purchase from the Veterans Law Blog, any book or training video that you purchase as an add-on to your membership. You'll get a 15% discount. And as you'll see, starting next week, premium members will get opportunities to join webinars for free. So we're going to start doing webinars here in the next week or so on a variety of VA claims topics. Those webinars are going to be anywhere from 60 minutes to 90 minutes long. They're going to be live, and they're going to teach veterans how to handle unique aspects of their claims. And so you'll be able to choose to join one of those webinars, and premium members will have the opportunity to join for free. So that said, I got the business end of this out of the way. I want to tell you some good news. Those of you who have been following for the last few weeks know that I was up running the New York City Marathon in early November, and I was able to finish the marathon. Ran it in a time of 5 hours and 42 minutes and 13 seconds. So it's certainly not Olympic fast. It's not going to win any awards in any national competitions, but I'm really proud of that time right there. I ended up getting, I want to show you guys the medal I got. I'm going to see if I can lift it up here and see if y'all can see it. Get it close. I'm not sure how that looks on the screen. But anyway, there's the front of it right there, and then the back side of it, I'm going to get engraved with my name and my time. So in any event, pretty cool thing there. Did a fundraiser for a organization known as the Lila Kate Foundation here in Arkansas, and the Lila Kate Foundation gets resources to children with special needs in the state of Arkansas. Really great organization. Still taking donations for that fundraising effort. We've raised over $3,300, I think, at this point. Going to keep it open for a few more days longer. Go to irun41.org. So irun41.org. That link will be in the show notes. If you could donate $10, $15, $20 or more if you can afford it, sure would appreciate that. All those funds go to the Lila Kate Foundation that provides support to children with special needs in the state of Arkansas. So in any event, that's that. Marathon's behind me. I took a few days off to go run the marathon, and I learned that when you run a marathon, that it breaks your body down pretty good for a couple of days, including compromising your immune system a little bit. So I got pretty sick when I got home and was down and out for about a week, was off work, just trying to recover from that. It was a pretty horrible experience, that part of it was. But in any event, I'm back and healthy and back to at least back to 80% functioning right now. But I appreciate everybody who offered notes of congratulations and notes of support throughout the marathon. It was a tremendous experience. If you ever get the opportunity, I encourage you to do that. If there are any New Yorkers here on this live cast, I got to tell y'all, New York City, y'all have a beautiful city up there. From first crossing over the Verrazano Bridge, in running through Brooklyn, running through Queens, running through Manhattan and the Bronx. I got to see so much of that city all the way down to crossing the finish line in Central Park. It's a beautiful city. The personality of each of the 5 boroughs comes out in that race with the folks along the side cheering you on, literally 5, 6 people deep the entire 26.2 miles of the marathon. It's impressive what you all do up there, and it was an experience of a lifetime, and I want to thank the city of New York for that. So thank you very much. On to news in the veterans community. The big news is, of course, it's on everybody's mind, is our recent presidential election. Now, the Veterans Law Blog is not political. I'm not planning on starting now either. The beautiful thing about living in the land of the free and the home of the brave is that you're entitled to your political views, I'm entitled to my political views, and so is everybody else out there. So I don't care about any of all that. My political views don't matter. You're entitled to yours. Big question that's out there, though, is what does this election? It was a surprise for a lot of folks. Some of you are going to say it wasn't a surprise to you, and that's fine. But a lot of folks inside the Beltway were surprised by this. And so the big question out there today is what does this election mean for veterans and for the VA? It's a big question, and something that certainly I'm going to be keeping an eye on as we go forward. Our current VA secretary is a gentleman named Bob McDonald. Bob McDonald is not without his flaws. His VA administration has had its challenges, but I would say that it has been the most transparent Department of Veterans Affairs that I can remember in all of the, I guess, 10 years that I've been doing this. I've never known a VA secretary that you could pick up a cell phone and talk to him. I've never known a VA secretary that you could email and get answers from right away, sometimes faster than the actual bureaucrats who are supposed to be doing the work, right? So I do like Bob McDonald. I like what he's done. I wish he had done more. There are some opportunities I wish he'd taken advantage of. But the bottom line is, whatever happens as a result of this election, Bob McDonald is most certainly on his way out. There's been no indication from the transition team for the president-elect that he is going to keep Bob McDonald. And prior to the election, the folks that I know that run in those kinds of circles were all telling me that whoever got elected, whether it was Hillary or Trump, whoever got elected, Secretary McDonald was on his way out. So I think we can anticipate that. The concern is who's next, because what's going to happen inside the VA over the next 4 years, frankly, the next 10, 20 years, largely depends on who the Secretary of the VA is. The one name that's being mentioned a lot is Jeff Miller. Jeff Miller was a supporter and a backer of Trump throughout the elections. He was also the chairman of the House Veterans Affairs Committee for a number of years. He's a good guy. He's a really good guy. He's a solid man, a solid legislator. Whether or not you agree with his politics, again, I don't care. But he certainly did a good job as a legislator. He's also old school in the sense that he's not going to be like, if he does get the nod as the VA secretary, he's not going to be like Bob McDonald, where you can email him and get an answer. If you wanted to talk to him at a position as a House Veteran Affairs Committee chairman, you had to go through about 6 or 7 tiers of people before you could ever get to him. It was quite challenging, very, very, very old school. But again, a decent guy. My big problem with Jeff Miller as a secretary of the VA is that it's more of the same. It's more inside the beltway nonsense. President-elect Trump campaigned on the concept of draining the swamp, and as much as I like Chairman Miller and applaud him for his service to veterans over the years, he very much is a part of the swamp that is the VA. For example, all these years that he was the chairman, he had the ability to hold the VA's feet to the fire by using the power of the purse that Congress has and the power of the subpoena. And he never really chose to exercise that power. He spent a lot of time on the press complaining about the VA lying or not answering things straight, and never spent a lot of time really holding their feet to the fire. So I would be a little disappointed if he's the chairman of the VA, not because he's a bad person, but just because I think it's more of the same. And one thing that we can take from this election is that veterans did lead the charge in a lot of ways of saying that it's time for something different. We still have a lot of problems in the veterans community that we need dealt with. We need help addressing them. We have 22 of our brothers and sisters every day are committing suicide. We have 30% of us that didn't even vote in the election this last time, estimated 30%, which means that 30% of veterans don't feel like they have a voice in the political system out there. On top of that, if you use the VA's own report and their own statistics from this past August, veterans that get mental health treatment from the VA are 25% more likely to commit suicide than those who get mental health treatment outside the VA or don't get mental health treatment. That's a pretty pathetic statistic if you think about it, that going to the VA makes you more likely to commit suicide. And it's one of the biggest problems that I have with the VA medical side of the house. On top of that, it takes a veteran an average of 26 days to get a comprehensive mental health examination. So if I was to walk out there in the city of Little Rock, pick up the phone and call up any mental health therapist and say that I'm feeling suicidal, I can almost guarantee that that therapist is either going to get me in the door that day to talk, or they're going to find a place for me to go really quick that day to get a comprehensive mental health exam, or if I need a bed in a hospital. That's not the case with the VA. You call up and you make that complaint, you got 26 days before you get a comprehensive mental health exam, and it's pathetic that that's happening. Veterans, on top of that, this current conflict, Afghanistan and Iraq, veterans are coming back with traumatic brain injuries that the VA doesn't understand and can't treat, coming back with conditions like CTE, coming back, they're not able to distinguish between that and PTSD because they're not studying it. Veterans have breathing problems from all the burn pits that were over in Southwest Asia, in Iraq and Afghanistan. Every base over there burned trash and God knows what else, and all that particulate matter is getting into the lungs of all the servicemen and women that are over there. And nobody's really doing the studies to say, what's the lasting problem? What's the solution? How do we get these folks fixed? Veteran unemployment rates are twice what they are in the civilian world. And 47% of veterans that are unemployed have been unemployed for 6 months or more, meaning that they've dropped out of the labor market. So those are pretty significant statistics that we're talking about there, pretty significant problems. Throw on top of that the fact that it's very difficult for a veteran to integrate into a civilian community after 2, 4, 8, 10, 20, or 25 years in the military. We don't understand how the school systems work. If we don't have medical care for our families through any of the Department of Defense insurance plans, TRICARE, anything like that. Like my family, they don't get medical care through the VA. Frankly, I'm scared to death of the VA, so I don't get it from them. And so I've got to navigate a civilian medical care system, which is frankly very different from what it was in the military, and it's very difficult to understand, and it can be very costly at times too. School systems are nothing like they were on military bases. There's a whole new world to navigate, and there's not any tools that really are given to veterans to figure that out. So we've got a host of problems going into 2017 that have never been addressed by any politician on either side of the aisle, in either house of the Congress, in the White House, or frankly, even in the courts. Veterans are largely, in my opinion, and I talked about this on Veterans Day, we're thrown up on a pedestal whenever somebody needs a flag or patriotic music. But when push comes to shove and it's time to do some shit for us and help us readjust and fix some of the problems that we have, nobody's around, or it's too difficult, or we just have to wait on the political process or whatever other nonsense. So I'm really eager to see who the new VA secretary is. I want to tell you about who I'm putting my money behind. Not that it's about money. I'm backing a guy named John Wells. Now, John is an attorney, and he's got a long track record of fighting for veterans that are trying, particularly the Vietnam era veterans, to put to bed all these stupid rules about Agent Orange exposure. He's been dedicated most of his life to fighting for that. He understands the system on the benefits and the health side. He's not one that's going to accept a lot of bullshit from anybody. If you know John, you know that to be true. There is a movement that some veterans have started to try to convince the Trump transition team to at least take a look at John for Secretary of the VA. And in the show notes, I'm going to post the links to a couple of things, to his Facebook page that talks about what he wants to do as Secretary of the VA, and a page where you can ask the Trump transition team to take a closer look at John Wells as the Secretary of the VA. So enough about that. That's the big current event thing that's going on there. There's some other things I wanted to talk about, but if I keep talking about this sort of stuff, we're going to run out of time to talk about the VA claim stuff. So in any event, let's talk about our main topic today. And the main topic that I wanted to bring up to y'all is the VA claims process itself. And so I take it for granted. I've been doing this since 2007 as an attorney, as an accredited VA attorney, battling the VA for veterans. Since 2007, I think was my first case. So I take it for granted that what this process is and how it works. And so when I talk to folks about it, I've been doing it so long that I can talk very quickly and run through, and you guys know I talk fast, and I could run through these steps very quickly. And I take it for granted that you guys all understand that process as well. And that's not true. Of the 65,000 veterans that follow us on Facebook, I would be willing to bet that half of you don't know the VA claims process, even though you want to know it. And some of you don't want to know it in the first place, and maybe after hearing this, you won't want to know it. It's a very complicated, very tortured process, but I believe it's important to understand the general contours of this process and how it works, because once you understand how it works, then you can start finding the gaps in the system that allow you to push your claims through faster and get better results and cut through the fog. And that's largely what the Veterans Law Blog is all about. I've studied this system so much that I know where the weaknesses are in the VA. And I say weaknesses because this whole thing is, I always discuss it in context of it's a battle, it's a fight. A lot of times it's not supposed to be an adversarial process, but it is. And so I talk about it in an adversarial context. Ideally, it shouldn't be that way. And someday, hopefully, we'll be able to drain that swamp and fix the VA claims process. I don't see it happening anytime soon. A lot of politicians and a lot of special interests are tied to this process, but I'm going to walk you through it so that you can understand the basic life of a VA claim from the time that you seek benefits until the time that you go all the way through the hamster wheel. If you're going to go that way, some of you are lucky and get your claims decided pretty early. Others of us have to fight for almost this entire process. But in any event, let's walk through it. So the very first thing that you're going to do, and I'm going to set my piece of paper here down with my notes. I hope I don't knock my camera over. The very first step in the VA claims process is filing a claim. And a claim consists of four things. Most claims for service connection consist of four things. You have to have eligibility. You have to have a service-connected disability. You're going to get an impairment rating or a percentage that shows how much that service-connected disability impacts your life. And you're going to get an effective date, and that's the date at which benefits start. So those are the four pieces of any claim. You're going to file forms with the VA. You're either going to file a claim, original claim, A claim for an increase in benefits, if you've already been granted service connection and you want a higher percentage rating, you would file a claim for increase. If you've already filed an original claim and it's been denied and you can't appeal it, you can file a reopened claim where you submit new and material evidence to the VA, and they'll reopen and reconsider that claim. You can also file, I'm going to say this, and somebody listening to this is going to know that I'm mixing some words here, but you can file a Q claim. A Q claim technically doesn't really exist. It's as the court wants it to be called, it's a motion to revise your effective date in a prior ratings decision based on clear and unmistakable error. So that's a mouthful. It's just easier to say Q claim. So those are the general types. There's survivor claims. There's all sorts of different claims, and those get filed with the VA regional office. Each state has their own VA regional office, or VARO, or VARO. Some states like Texas are big enough, and California are big enough that they have 2 regional offices. Okay, so when you get that claim filed, it's going to be, the VA is going to develop evidence to support that claim. Now, there's certain types of claims called fully developed claims where you develop the evidence. That's not what we're talking about here. I'm talking about the standard claim where you submit it to the VA. Oh, we got a little bit of a lighting issue here. See if we can fix that. All right. I was hoping that the reflection off my bald head here would help to light this room here a little bit, but it's not working out that way. So there we go. All right. In any event, you're going to file your form, and the VA is going to ask for certain evidence, or they're going to try to develop the evidence in those 4 pillars to try to get you benefits granted. They're going to issue what's called a VA ratings decision, or a VARD as I refer to it on the blog. That VA ratings decision is either going to grant benefits or it's going to deny benefits. It can grant service connection or it can deny service connection. It can grant an impairment rating or it can deny one. It could set an effective date or it could deny one. It could do all those different things. That's the very first step. You filed the claim, you get the VA ratings decision back. 1 year from the date that they send out that VA ratings decision. In other words, there's a cover letter that goes with it. It's called the Notice of Action Letter. So there's a 2 to 3, sometimes 4-page cover letter, and on the back is the actual ratings decision. The ratings decision has a date on the front of it, as does the cover letter. The cover letter date in this example is the most important one because you have 1 year from that date to file an appeal if you disagree with the VA's decision. Some folks will tell you that you can seek reconsideration. And I'm going to tell you, we've got stuff on the blog about this, but it's bullshit. There is a trick that is played on veterans that says, don't appeal this denial of benefits. Ask for a reconsideration and we'll take a look at it. Or if you filed an appeal, they will tell you, withdraw your appeal and ask for reconsideration and we'll take a look at it. And what they end up doing is taking so damn long to relook your case that you miss your appeal deadline. On top of that, there is absolutely no process in any of the Code of Federal Regulations, the U.S. Code. There is no process that allows the VA or requires the VA to issue a decision on a reconsideration request. So you can ask them to do that. They're not going to most times, or when they do it, they deny it after your time to appeal has already passed. So you can also go ask them to milk your cows for you. They don't have to do that. They're not going to do that. That's what I think of the VA reconsideration process. I think it's a trick. I think it's bullshit. Don't fall for it. Excuse my language. I feel pretty strongly about it. But in any event, there's going to be a post on that topic in the show notes that you can read more about it. But in any event, you have 1 year to file that notice of disagreement, or a NOD as it's called, and it's filed using VA Form 21-0958. I also advise veterans that they should put a little bit more information in their notice of disagreement, and I'll put a link in the show notes to a post that talks to you about the key ingredients of what you should put in a NOD. I've also got some videos on the blog that will walk you through a VA ratings decision so that you can pick it apart and decide whether or not you want to appeal it. But in any event, you file your notice of disagreement, and the very next step is an optional one at this point. The very next step is, do you or do you not want to request a decision review officer, or a DRO? Now, a DRO is supposed to be the more experienced VA raters. That doesn't necessarily mean anything. They could have only a couple of years experience. They may have a decade or more experience. They're just the more experienced out of the bunch of raters that they're in, which doesn't say much. but they're going to relook at your claim. Once you filed a nod and request a DRO review, they're going to take a look at it and see if any errors were made. You have the opportunity to request a conference with that DRO, and I strongly recommend that veterans take advantage of that. There's two types of conferences. There's an informal conference with a DRO, and there's a formal conference with the DRO, okay? The informal conference is simply a phone call. It's VA bureaucratic overusage of words for telephone call from a DRO. A formal DRO conference is one where you'll actually go into the regional office. They'll roll out the tape recorder. I'm serious. It is an actual tape recorder that they will record that hearing or conference with you. And you'll have a discussion, it's usually very one-sided, about why you think the VA should change its decision based on your notice of disagreement. So I have found that the informal conferences are a lot better. First of all, because you can do it over the phone. Second of all, because it's informal and because it's not being recorded, I think the raters feel a little bit more flexibility and freedom to talk to you more frankly about your case. When they know they're being recorded and they're going on the record, they have to be very careful to watch out for the government's interest as well. And so they don't want to misadvise you of anything or give you bad advice or give you bad information. So they're very careful, almost to the point of being silent in the formal DRO conferences. So that said, if you go through this DRO conference, generally speaking, there's one of two things that's going to happen as a result of it. The VA is going to change its mind and they're going to issue a new VA ratings decision, or they're not going to change their mind and they're going to issue what's called an SOC, or a statement of the case. Okay, the statement of the case, there's posts on it on the blog. I do a walkthrough of a statement of a case to show you how to pick one apart. It's almost, I think it's an hour-long video where we walk through step by step through a statement of the case to see how to pick it apart. Okay, that statement of case is important because it triggers another important deadline for you. Okay, and that deadline is the deadline to file the substantive appeal. Okay, a substantive appeal has to be filed within 60 days of the date of issuance of the statement of case. Remember how with the VA ratings decision we looked at the cover letter? We don't do that with the statement of the case. The statement of the case in the upper right-hand corner has a specific date on every single page in the very top right corner box. That date is your deadline or your start point for calculating your deadline for filing your substantive appeal. You have 60 calendar days, not 60 business days, not 60 days excluding weekends or holidays. It's 60 calendar days, no matter what, counting the day of the statement of the case. So calculate that deadline and you're going to file your substantive appeal. Now, I keep saying that phrase, substantive appeal. A lot of folks say VA Form 9. There's a reason I'm not saying you file your VA Form 9, and that's because the regulations do not require that you use VA Form 9. All that you have to do is submit information that contains what the VA Form 9 has. It's a little dangerous, but that's a good thing to know if you're looking back to try to figure out, if the VA is saying that you were untimely in filing your VA Form 9. Go back and look in that 60-day time frame after the statement of the case and see if you submitted anything in writing that could potentially be argued meets the elements of a substantive appeal, and then the board has to decide whether or not you met that timeline. So you're not required to use the VA Form 9. I strongly encourage you to do so. The VA is very form-based, always probably will be form-based, so use that form to file your appeal. What's next after you file your VA Form 9? It's going to a place called the Board of Veterans Appeals. So what the VA does down at the regional office is they take your ratings decision, your notice of disagreement, your statement of the case, your VA Form 9, and they package all those things together with your C file, with your claims file, and they send it to the board. Okay, the process of sending it to the board is called certifying the appeal. They certify that all of the boxes have been checked to get that appeal to the board, and then it goes into the board's queue or the wait line for the board. The board will, depending on your request, you can request a video conference hearing, you can request an in-person hearing at the BVA office in Washington, D.C. You can waive a hearing and submit a brief. There's even a process that I'm going to tell you about pretty soon on the blog that allows you to have a pre-hearing conference with the board judge. But you're going to request some type of interaction with the board, and depending on what type of interaction you requested, the hearing, the video conference, or the brief writing is going to determine your timeline. So let's say you requested a hearing. The first thing the board is going to send out, and it may be a year or more before you get this document, but the first thing they're going to send out is the docketing letter. The docketing letter says, hey, wait a minute, we've gotten the certified appeal from the regional office, and we are putting this in our queue, and we're docketing it so that we know that it's coming up for a hearing. Now, the line for the hearing is long, and it's largely determined based on the date of your VA Form 9, okay? So if you file your VA Form 9 today on November 18th, 2016, technically that's supposed to drive your docket date. So if you file it November 18th, 2016, you should have a 2016 docket date. If you filed your VA Form 9 in November of 2012, and the board got certified to the board in 2015, your docket date should be a 2012 docket date. That way, you come up in the queue a little bit earlier than veterans that filed later. So you get that docketing notice, take a look at your docket date and see if it matches your VA Form 9 date. Once you got the docketing letter, the next thing that you'll get is what's called the 90-day letter. And that's how you know that the board is getting close to setting you for a hearing if you requested one, or getting close to issuing a decision, if in fact you've only requested a decision based on a brief. That 90-day letter is kind of a weird letter because it is not saying that there's a 90-day deadline to submit new evidence to the board, although that's what a lot of people interpret it as saying. What it is saying is that we are not going to decide your appeal for at least 90 days to give you time to send stuff in. So you can send stuff in, new evidence, new arguments, up until the day the BVA issues a decision. And it still is timely, and the board is still supposed to be considering that information. If you have a board hearing tomorrow, today, well, you wouldn't have one on a Saturday, but if you had a board hearing on next Tuesday, all the way up through the time of that board decision, which could be months after that hearing, you can submit new evidence, new arguments, additional evidence, additional arguments, okay? So that 90-day letter basically says, hey, we're not going to do anything for 90 days. If you want to submit something, go ahead and send it in. That gives you a heads up that the BVA is looking at scheduling a hearing or looking at issuing a decision. And the next document you're going to get if you requested a hearing is the hearing scheduling letter, and it's going to tell you the date and time. If it's video conference, they're going to tell you what regional office to show up at. If you requested a hearing in person in DC, they're going to give you the instructions on how to get there. And then you're going to have your hearing with a board judge. Okay, once the board judge holds that hearing, and it's not a very formal hearing, but most times when it's a video conference hearing, you're sitting down at an old 1950s style metal desk that's in a VA regional office talking on camera to a judge who's sitting probably, in all likelihood, in his or her office in Washington, D.C. If you are doing an in-person hearing, you're really sitting down at a table across from the judge. It's nothing fancy. And I only mention that to you because a lot of folks, I think, are going in there expecting to see a full-blown law and order type hearing, and that's just not the case. So in any event, the board holds its hearing, and then at some point after the board hearing, it issues the BVA decision. Okay, the BVA decision could do any number of things. It can affirm the decision of the regional office, meaning it agrees with it, or it denies your appeal. It's one and the same. It can reverse the regional office decision, meaning they disagree with the regional office finding and they're going to make a different one. It can remand your claim, which means send it back to the VA regional office for additional evidentiary development, or it can refer your decision back to the regional office. Referral occurs in a very weird set of circumstances where there's an issue before the board that has not yet been raised through that certified appeal process, and the board is saying, we don't have jurisdiction legally over this yet, so we're going to refer it back to the regional office for them to consider it. So I'll give you an example. In a recent case of mine with a firm, my client had an injury to his right knee. We got all the way up to appeal before the board, and he mentioned in his hearing testimony that his doctor just told him that because of that injury to the right knee, he now needs a knee replacement on the left knee because he's been putting so much weight on the left knee to make up for the problems with the right knee that his left knee's gone out. And so the judge in that case referred the left knee claim back down to the regional office. You wouldn't remand that claim because it's never been claimed or decided before. So see how that's the difference. The board decision can also mix those reliefs up. And so it could say, for this claim, we're going to grant, this one we're going to deny, this one we're going to remand. It can get to be a jumbled mess. If you are denied by the BVA, then your next step is to appeal to the Court of Appeals for Veterans Claims, which is an Article I court, meaning it was created by Congress and is a legislative court in Washington, D.C. that can only look at legal questions. It can only decide whether the BVA erred in an interpretation of law, an application of law to fact. It cannot actually decide facts. Okay, so if there's a factual dispute, it's probably going to kick it back down to the BVA to fix that, to make a decision on the factual dispute before it can issue a decision. So the Court of Appeals will make a decision, and the same types of relief apply. It can affirm, deny, refer, or remand the case back down to the BVA, or it can combine any of those reliefs. Okay, so if you're denied by the Court of Appeals for Veterans Claims, at that point, the only option that you have is to file with the Federal Circuit Court of Appeals. The Federal Circuit Court of Appeals is an Article III court, meaning it was created under Article III of the U.S. Constitution. It's a true judiciary court, and the only one that most veterans would ever see when they file their claim. It's ironic, if you're not in this country lawfully, then you get an opportunity to go before an Article III court. If you're accused of a crime by the federal government, you get a chance to go before an Article III court. If you're accused of cheating on your income taxes, you get a chance to go before an Article III court. If you're applying for Social Security disability, you get an opportunity to go before an Article III court and actually have an actual federal judge decide your case. But if you're a veteran and you fought and bled and died, or you're a survivor of a veteran that died, but if you fought and bled, if you got injured in the course of your military service, all that stuff, you did that, you still never get to see a federal judge in your claim. It's ridiculous. It's absolutely absurd. Neither here nor there. I could go on a rant forever about that. But you go to the Federal Circuit Court of Appeals if the Court of Appeals for Veterans Claims deny you. And what's unique about the Fed Circuit is, first of all, it's one step below the U.S. Supreme Court. And it's very, very limited in what it can decide. It can only usually look to see if the Court of Appeals made an error interpreting a statute, made a constitutional error. In other words, they erroneously decided or failed to address a constitutional issue, or in some cases, whether the Court of Appeals erred in applying law to fact. That's really rare for those sorts of things to happen at the Fed Circuit, and so most of the time the Fed Circuit declines jurisdiction or denies the appeal. So if you lose at the Fed Circuit, you can go to the Supreme Court. Supreme Court has an extra step that you have to request certiorari or request cert. You have to ask the Supreme Court if they would like to review it before they would actually review it. So you don't get an automatic appeal right to the Supreme Court. It's a common misconception out there. You get to submit your issue to the court, and they get to say, yeah, this is interesting enough for us, this is significant enough for us, or we're not even touching that yet. Let's let that percolate a little bit lower in the process for a while. Most veterans don't ever see the Supreme Court of the U.S. I think that there may be, a couple dozen that I can think of in the last 10 years that have gone to the Supreme Court. So that's the process in a nutshell, a very long nutshell, very large nutshell. And you can see a couple of things from that. You can see, first of all, it's incredibly complicated. There are a lot of blocks that you have to check, a lot of steps that you have to follow, and a lot of hurdles that you have to pass through. Your goal should not be to go through every one of those steps. When you file a claim, your goal should be, consider it like a special airstrike, a special forces airstrike on a high opportunity target. You want to be in and out. You don't want to spend a whole lot of time in the VA. The more time you spend in the VA, the more likely you are to get a bad outcome. So your goal should be to get out as quickly as possible. And most veterans can do that by filing a better claim to begin with. So there's some training on the Veterans Law blog that will teach you how to file a VA claim, specifically how to file a fully developed claim, so that you can hopefully get the best outcome in your initial decision and not have to go through all that nonsense, because it can take 8, 10, 12, 16, 20 years to get through that process. So that said, I hope that walkthrough was helpful. It's confusing, but it's important to understand those steps because I see a lot of veterans that want to try to jump the steps or don't know where they all fit in. They want to immediately go and get a board hearing, and you can't do that. You've got to follow the steps. You've got to follow the process. But in any event, that said, I almost need a sip of water after that whole long talk. Oh, I guess I forgot water. So we're gonna keep pushing on through this. So the next thing that I want to talk to you all about, and there'll be some links to posts in the show notes that talk you through each of those steps. I've got one that actually walks through those steps, and we also have an ebook on the Veterans Law blog called the VA Claims Process Field Manual that talks to you about each of those steps, what's important to do at each of those steps, why they are there, should they not be there, what you need to do in each of those levels, what outcomes could exist, where to get help on those things. That's all covered in the VA Claims Process Field Manual, which you can purchase and download as an ebook from the Veterans Law blog shop. So go to veteranslawblog.org/shop, and you'll find that book, as well as dozens of other books that I've published in there as well. So let us jump into your questions. So these are questions that users have submitted, users of the Veteran Law blog premium members. Folks on Facebook have submitted some questions. I look through each of these questions. I get hundreds of them every week, and there's a lot of them. And some of you guys have some really good questions. So I've got kind of a whole backlog that I could probably do these Q&As every day for 2 or 3 years and not get to all the good questions y'all are asking. So what I do is I go through the list of questions and I look for the most common questions that veterans are asking. So if I see 5 or 6 or 7 veterans asking the same question, then I think that's something that veterans need, more veterans probably are asking, and more veterans need to know the answer to. So that's what I'm looking for. And where I can, I will submit, individual answers to you, to your questions. It's a little bit harder to do because I don't want to get into the business of giving legal advice. The Veterans Law blog is not a law firm. I'm a VA accredited attorney, and I, maintain current training in that. In fact, I serve on the National Organization of Veterans Advocates Board of Directors, which provides probably over 60 hours of training every year to attorneys that want it in the area of VA benefits. But the Veterans Law blog is not a law firm. And anything you find on there, I've got to tell you, it doesn't substitute for good legal advice. So one of the books that's on the blog is How to Choose a VA Claims Attorney. If you're looking for legal advice, get that book. It's absolutely free. You can download it, not pay a dime to download the ebook version of it. Read through it. You'll figure out where to find these attorneys, what questions to ask them, how many should you interview, how many should you talk to, what should you be looking for, what should scare you away from an attorney, what kind of fees do they charge. It's got all that information in it, and I encourage you all to take a look at that to understand all you can before you hire an attorney. But get legal advice on your specific claim from an accredited VA attorney. No blog, no ebook, no video training program, whether it's on this site or any other site, whether even on the VA's website, even on a VSO's website, even on the Veterans Law blog. None of that stuff can take the place of a good legal advice from an accredited VA attorney. I know there's a couple of you guys out there saying, all right, Chris, you say this every time. Why do you have to keep going over? Just move to the meat of the conversation. And I'm only telling you this for a couple of reasons. First of all, every time we do these videos, somebody new is on here and they have a right to hear that information. The other reason is the state bar requires that I tell you that information. So as an attorney, I'm required to do certain things, and I'm letting you know we're not going to give legal advice. But the bottom line is I do my best to answer these questions generally as they apply to most veterans, knowing well that you guys are going to understand that this is not legal advice, and you're going to understand that this is not specific claim advice to follow, okay? So with all that said, let's jump right into the questions. The first question is from an individual named Brian, and his question is, how do I reopen a claim for asthma that was service-connected at 0%? I'm on daily medication, and I believe I'm entitled to a 30% rating. So basically his question is, I've been service-connected for asthma, I'm rated at 0%, I think I should be rated at 30%, how do I reopen that claim? Okay, let's get some language out of the way. Anytime I answer a question, I gotta lay the groundwork with the language so that we are talking apples to apples, okay? The first thing is, any VA service connection claim, I mentioned this earlier, has 4 elements, primarily 4 elements, and I call them the 4 pillars. If you talk about the 4 pillars to the VA, they're not going to have a clue what you're talking about. That's ADIG language. The 4 pillars are, you're eligible as a veteran. You've got a service-connected disability. The third pillar is that you have a rating, an impairment rating for that service-connected disability. And the fourth one is you get an effective date. And the effective date is the date on which your compensation becomes effective. In other words, when they start paying you money starting. Okay, so those are the 4 pillars. Now, the first 2 pillars of that, eligibility and a service-connected disability, are known as the upstream pillars, all right? Impairment rating and effective date are known as downstream pillars. Now, I don't know why they came up with the language. Sometimes I think, I love being a lawyer. I'm really glad I'm a lawyer. But sometimes I think lawyers just invent some crazy ass shit just to justify high hourly fees and also to sound a hell of a lot more intelligent than most of us really are. So why they call it upstream, downstream, who the hell knows? But it's in the court documents and the court decisions referring to them as upstream and downstream. In a different setting, they might be considered liability and damages. That's the language most lawyers are more familiar with, but it's a unique process here where you don't actually have to show that the VA or that the military branch is at fault for your injury. But in any event, all that has a point, is that the only types of denied claims that you are going to file a claim to reopen for are denials of service connection. Okay? If you're denied, your impairment rating is set at 0 and you think it should be 30 or 60 or 70 or 90 or 100, or if your effective date is assigned as 1 day and you think it should be another one, those two things, you don't challenge those through a claim to reopen. The impairment rating, you're going to challenge in one of two ways, depending on how long it's been since that ratings decision. The effective date, there's two different ways to challenge that. So let's walk through all of this. You get a VA ratings decision, and in this case, in Brian's case, it's an asthma claim, and he was granted service connection for his asthma. Let's change the facts up a little bit just to illustrate how this works and say that he was denied service connection for his asthma. The way to challenge that, if there's 1 year, still remaining, I'm sorry, I'm getting that kind of confused there. If you have, you're still within the 1 year appeal period, the veteran can challenge that denial of service connection by filing a notice of disagreement. Okay, if it's past the 1 year period, the veteran can file a claim to reopen that claim for benefits. Now, to do that, you're going to have to provide new and material evidence. I don't know why I'm having trouble talking all of a sudden. New and material evidence as to the elements for the denial. So if your claim was denied, your claim for asthma was denied because there was no nexus of the asthma to your military service, you're going to have new and material evidence on the issue of nexus. If you were denied because you're not eligible as a veteran, you're going to have new and material evidence that shows that you're entitled to it. Usually that involves a discharge upgrade is what they're talking about in most situations there. In those situations, you file a claim to reopen. Okay? Go back to Brian's original facts. He's got an asthma claim. All right? He was granted service connection, but given a 0% or a non-compensable rating. Okay? He thinks he's entitled to 30%. Two ways to challenge that depending on how long it's been since the decision. If you're still within the 1 year appeal period, you can file a notice of disagreement and challenge their assignment of a 0% rating. You're going to put in evidence, and I talk about how to do this on the blog with lay evidence, with medical evidence that shows how you're entitled to the next higher level or whatever rating you think you're entitled to. Now, if you're past that 1 year time frame, if you're outside the 1 year appeal period and you still disagree with that 0% rating, the best thing to do is to file a claim for increase. And that's a claim for increase in compensation. So there's an actual form number for that. I'll put it in the show notes. And you're going to argue that your condition has worsened since the time of that grant and that you're entitled to more. You can also file a Q claim, but Q claims on ratings are really hard. Basically, what you're saying in a Q claim is that in a prior final decision of the VA has committed clear and unmistakable error in the assignment of the rating of 0%. Good luck with that. That's a really hard proof, really hard. And Q claims on the assignment of the percentage, you have to show that the error is clear and unmistakable. And most times, depending on what's in your C file, the VA is going to be able to make at least a plausible or a believable argument why they assigned the lower rating. And that's ultimately what the court's going to look at. So you lose your Q claim unless the court can look and say it is clear that an unmistakable error, nobody that looks at this could have decided any differently. That's really hard to do. So that option's there, but it's really not a realistic option. So effective dates. Let's say you get an effective date assigned, you're granted service connection for your asthma, you're assigned your 0% rating. Let's say you're happy with that, but you want an earlier effective date. Why would you want an earlier effective date on the 0% rating? Well, some states some benefits in some states and some federal benefits, and certainly in the contracting process, may derive from even a non-compensable rating. And so you're going to want to have it. You can have property tax discounts in some states, some counties, some cities that are driven by the date of your rating. And it doesn't matter if it's a 0%, 10%, or 100% rating. So a lot of times veterans will still want an earlier effective date for that particular claim. And if that's the case, again, you look to how long you've got to appeal. If it's past the 1-year appeal period, you're going to have to file a Q claim. Simple solution right there for effective dates. The only way to challenge an effective date once the appeal period is passed is to file a motion to revise a prior final VA ratings decision based on clear and unmistakable error. Those are a little bit easier to win on the effective date. I'm not saying they're easy at all, but they're easier than the impairment ratings because it's often not a question of fact that you could argue about. It's pretty clear in the record what the facts are. They're usually not disputed. It's whether or not the VA properly applied the effective date rules. And a lot of times you can catch them making some pretty significant, clear, and unmistakable errors. But that said, hopefully that answered your question, Brian. The bottom line is, if the only time you're going to want to reopen any claim is when it's past the 1-year appeal period and it's a denial of your benefits based on lack of eligibility as a veteran or failure to service-connected condition. If it's an impairment rating or an effective date, appeal, file Q, or in the case of the impairment rating, file a claim for increase. So hopefully that helped. It was a confusing process, and I know a lot of vets do get confused, but it's important to understand those, because if you file the wrong type of claim, you're going to confuse the VA bureaucracy too. And once the VA bureaucracy gets confused, they don't often try to figure things out. The more confusing a claim gets, the more likely it is to become a footrest. And so you really want to try to make these claims as clear as possible for the VA so that your claim doesn't end up being a footrest for some rater somewhere. So in any event, question number 2 comes from a gentleman named Airman Anthony. So his question is this. I'm going to go ahead and read it here. If the BVA granted a disability percentage rating with the proper effective date, but after sending the decision to the Appeals Management Center, they made an error with the proper allocation of the effective date, should the veteran contact the AMC before the award is received to correct the date? Well, so let's simplify that question. What the veteran is saying is the BVA granted service connection and assigned an effective date. They sent it back to the AMC to effectuate that decision, to take action on their decision, and the AMC assigned the wrong effective date. And he wants to know, do I call him up and say something before this decision goes out, or what do I do? So let's, again, clarify some jargon. The first thing is, we know what the BVA is because we just talked about the VA claims process. And so this veteran has filed a claim. It's been denied. He's filed a notice of disagreement. He's gotten a statement of the case. He's filed a VA Form 9. It's been certified. He's gotten his docketing letter. He's gotten his 90-day letter. He's gotten the board hearing letter, right? See how this process works? Airman Anthony asking this question, I would almost be willing to bet, has been in this process for 6 to 8 years already. So he gets all the way up to the BVA, and the BVA gives him a decision that he agrees with on the rating. They rated his claim properly. He agrees with it. And they gave him the right effective date. Okay? What's the AMC then that the BVA is sending it to? Who is that? So the Appeals Management Center, or the AMC, is a Band-Aid. Many years ago, and it's still there. I mean, the appeals backlog is huge. So there's hundreds of thousands of cases sitting in the BVA's backlog queue. And it was the case 10, 15, 20 years ago that they had all these appeals backlogged as well. And they were remanding a lot of them back down to the regional office to fix mistakes or to fix evidence that they'd failed to develop or to answer questions that they had not answered. And it was taking an awful long time because the regional offices were backed up then as well. And they're still backed up. They've crunched the numbers to make it look like they're not, but they are. And any rater will tell you that they're still under an onerous backlog. But in any event, somebody got the bright idea that as a Band-Aid, we're going to give the board their own regional office, and they called it the Appeals Management Center, or the AMC. Now, not every veteran has the ability to get their case before the AMC. Only veterans that are pro se, meaning they're not represented by an attorney, get an opportunity to go to the AMC. So if you're represented by an attorney, your rates of remand such that you're going to wait a long time are a lot lower. Attorneys have some pretty high success rates, so they wouldn't necessarily need to get to the AMC, but it's generally only available to veterans that aren't represented by an attorney. And so the AMC acts just like any other VA regional office. They're just supposed to be quicker about it. But they make a lot of mistakes. And like Airman Anthony mentions, in his case, they changed the effective date that the board had assigned and gave him the wrong one. So what does he do about that? Unfortunately, when the AMC issues a decision, it is a VA ratings decision. So unfortunately, if they got the date wrong, you're going to have to file a notice of disagreement. You're back in that hamster wheel again. So you're going to have to file that notice of disagreement, and then you're going to have to go through the process again. The good thing is that the board is on, if the BVA is on the record saying your effective date is X, and the Appeals Management Center comes back and gives a completely different date that's worse for you, you've got a pretty good appeal basis right there. And if you request a DRO hearing back at the regional office on that, and you say, look, the board said it's supposed to be January 8th, 2009 as my effective date, and they assigned August 1st, 2009. And so that's wrong. I'm missing 7 months of benefits. Most DROs are going to say, gotcha, that's a quick fix, and they're going to take care of that. But the thing is, you're going to have to appeal it through a notice of disagreement. The tricky thing about the AMC is this, and I'm going to put a post on the blog that talks about this, but there are some decisions that come out of the AMC that say they are a BVA decision. And so it gets confusing. All right, it looks like a VA ratings decision, but it says this is a decision of the Board of Veterans Appeals. So what appeals timeline applies? The safest thing you can do is appeal to the Veterans Court and lose. And have the Veterans Court tell you, no, that's a ratings decision, you've got 1 year. That way you're safe, all right? If you don't do that, then the regional office can come back and say, oh, it was a BVA decision, you had 120 days. Then you have to nod that decision. You have to get a statement of case, file a VA Form 9, wait 2 to 3 to 5 to 8 years to get a decision on whether or not you use the right appeals timeline. So it can get a little tricky with the AMC. The best thing to do is have an accredited VA attorney take a look at it. Nothing is a substitute for good legal advice from an accredited VA attorney. If you trust your VSO, you can have them take a look at it, but when push comes to shove, if they're wrong, in 5 years, they're not going to be around to fix it if they make a mistake. So, an attorney, if they make a mistake like that, then you've got an option A of suing them for negligence. But you've also got the option to go into the state bar where they're licensed and argue that they committed malpractice by giving you the wrong information. And so if you have an attorney-client relationship with an attorney, in other words, you've signed a document with that attorney that says, you're my attorney, I'm your client, and they give you legal advice, and that legal advice not only is wrong, but is negligently wrong, then you might be able to get a bar complaint against them. So that's one advantage. I hate to say that's an advantage, but sometimes you don't want to be left holding the bag when the music stops, especially when the mistake is made by a VSO. So in any event, hopefully that answered your question, Anthony. Delvin asked a question that was very similar, and he said, what do you do if you disagree with the effective date that the VA assigned? And the answer is, if you have if you're in that 1 year appeal period, you file a notice of disagreement. If you're outside of that 1 year appeal period, then you file if you have an opportunity, you file a motion to revise the effective date in a prior final VA ratings decision based on clear and unmistakable error, a Q claim, right? Now, I'm going to put some posts in the show notes that talk about some different issues involved with a Q claim. They're really, really, really hard, really challenging. Some people win them. I know there's people on the blog that have done a great job using the information I've provided to win their Q claims, but there's also some people on there that have used that information and have not won. So they're really tough cases. Really, if you find yourself in a position where you have to file a Q claim, then all other opportunities are lost, and it's a last-ditch chance at getting benefits. And that may not be the best chance, but sometimes it's all you've got. I'm also going to put some posts in the show note that talk to you about effective dates. So the general rule in most VA claims is that your effective date is the later of the date you filed the claim and the date the entitlement arose. In almost every case, the date of the VA claim is going to be the later of those two dates, because it's rare that a veteran files a claim for a condition they don't have. But when they do, in certain cases, that can yield a different effective date. But bottom line is the general effective date rule says yields an answer that usually your original claim date is your effective date, so long as you met all the deadlines. So if you file a claim January 1st, 2015, you get your ratings decision in March of 2015, you file the appeal in March of 2016, and you win at the board in November of 2016, because you've met all of the deadlines in your claim, your effective date is going to be your original claim date when you win. Let's say you missed your deadline to appeal and you file, later on, file a claim to reopen. That has a separate effective date rule. Claims for increase have separate effective date rules, okay? If you're a Vietnam era veteran with an Agent Orange claim that comes under the Niemer stipulations, that has a whole basket of different rules. If the law changes while your claim is going on, and it's a favorable law change known as a liberalizing rule change, there's a whole new set of rules that apply. So there's a lot of effective date rules out there. So when you do get a VA ratings decision that grants you benefits, take a look. If it's anything other than your original claim date, you should be suspicious. The VA's number one error is that they like to take the dates somewhere around the date of the compensation and pension exam and make that your effective date. And then they argue facts found basis, that's when the entitlement arose, and it's later than the claim date. Well, that's nonsense. As long as you have met all the criteria when you file the claim, even if they later make a determination that there is nexus, it doesn't matter, that it's going to refer back to the original claim date. So just always be suspicious of a claim date that is different from your original claim, as long as you've met all the deadlines. And if you've got one of those other scenarios, or a presumptive condition related to Agent Orange or some other presumptive conditions out there, you might be entitled to other effective dates earlier. So again, the best thing to do is talk to an attorney. I will tell you that attorneys love claims and appeals that just involve effective dates, because it's our strong suit, is arguing. Usually when it comes to effective dates, there's not a whole lot of factual weighing of stuff to go back and forth. Those are challenging cases. When I'm trying to argue, like Brian had before, if I was trying to argue that he's entitled to a 30% rating versus a 0% rating for his asthma, that's a factual balance question. And so I've got to put just enough facts in to tip the balance in favor of my client or in favor of that individual. An effective date argument is different, and attorneys like them because it's the most pure type of legal argument. Is you're saying, we all agree on what the facts were. Here's when the claim was filed. Here's what the rule says. This is what you do. It's the most pure form of legal argument. Attorneys like pure claims like that, or pure appeals. So if you have any question, you shouldn't ever have a problem getting an attorney to take a look at your effective date appeal. In any event, let's move on to the next question and the last question before we get going. It's kind of a big one here. This comes from an anonymous veteran who said, the VA's denied my TDIU claim because they said I didn't file VA Form 21-8940. I know I did file it, but still, is this right? Okay. All right, so jargon again. TDIU, what is it? TDIU is a unique type of benefit. It's called Total Disability Individual Unemployability. And how TDIU works is if you have a service-connected condition and it's impacting your ability to engage in substantially gainful activity, then you can get a you can get a 100% rating, not based on the schedule for the condition, but based on the employability regs. So you don't have to be unemployed, although that certainly makes for a stronger unemployability claim. All you have to do is show that you cannot participate in substantially gainful activity because of your service-connected condition or conditions. What does substantially gainful activity mean? I got a post on this that's coming in the show notes, but ironically, nobody really knows what that phrase means. So we can safely assume that it means that if your income is lower than the federal poverty guidelines for your family size, then you're probably not able to engage in substantially gainful activity. If you are collecting Social Security disability for a condition, and that is also the service-connected condition that is causing you to be unable to engage in substantially gainful activity, you've got a pretty strong claim for TDIU. Okay, so nobody really knows what that term means, but there's some things that we can rely on in understanding what it means. If you own your own business, as a veteran. Or if you're engaged in some sort of sheltered employment, then that can help your TDIU claim as well. Or it doesn't even have to be you owning your own business. You could be, we work with one client whose wife owned a business, and his job, he was listed as a corporate officer on the business just because he's in the family, and that's what most family businesses do. But his job was to watch the bulldozer on the lunch shift. That's all he could handle in terms of his particular job. And so that then became a question of whether or not his service-connected disabilities limited his ability to earn an income, even though he was, he and his wife were making a pretty significant income, family income from this business. That's considered sheltered employment. So Congress has said you can't consider that income. Whole post on that about sheltered employment on the blog. I'll have it in the show notes. You should read about it. It's very interesting. It's not the only kind of sheltered employment. A lot of veterans get jobs at companies that they say, all right, we're only going to hire you because we like doing good things for disabled vets, so we're going to hire you. Or they create a position for a disabled vet, knowing that if the vet leaves that position, they're not going to rehire behind it. Those are other examples of sheltered employment. So and certainly that's evidence that you're not able to engage in substantially gainful activity. So that's TDIU in a nutshell. There's two types of it. The reg for it, if you're interested, is 38 CFR 4.16. And the two types are A and B. So A is known as scheduler TDIU. And the rule that applies there is what I call the 60-70-40 rule. Basically, if you have one condition rated at 60%, or one or more than one condition rated at 70%, one of them being at least 40%, the 70-40, then if you have evidence that those conditions render you unable to participate in substantially gainful activity, you can claim scheduler IU, okay, 4.16A. It's kind of a silly thing when you hear about 4.16B, which basically says it doesn't matter what your rating is. If it's 0%, 10%, 30%, 70, 90, 100%, it doesn't matter. Whatever your rating is, if your condition is interfering with your ability to get employment, substantially gainful activity, in other words, then you're entitled to TDIU on an extra scheduler basis. So the difference comes in how the VA does it. Typically, raters can make the decision on 4.16A, 4.16B claims have to go a little bit of a different route. And they're a little bit tougher to prove. It's a little bit tougher to show that a 0% rating limits your ability to engage in substantially gainful activity, but it's not impossible. So it's certainly something to consider about. In any event, when do you file a claim for TDIU? You file a claim for TDIU. You don't have to. The bottom line is there's no requirement that you file a claim for it. In fact, it's not even a claim, it's a benefit. So the VA is supposed to consider TDIU any time that a veteran seeks the maximum benefit when filing for service-connected compensation. Say that 10 times real quick. When you seek the maximum benefit you're entitled to under Title 38, and you indicate that because of a certain condition that's related to your military service, you're unable to participate in substantially gainful activity or you're unemployed, the VA must consider TDIU without you having to ever submit a claim. If you file a claim for increase on a previously rated condition, if you file a claim for increase and there's any indication in the file that that condition limits your ability to get substantially gainful activity, the VA is supposed to infer the TDIU claim. Now, they often don't. And I will tell you, as the questioner here asked, I almost told you his name there, that would have been bad. But as the questioner asked, the VA often denies TDIU claims when there's no form for TDIU in your file. So typically, in order to get a eligibility for TDIU, you file VA Form 21-8940, 21-8940. You file that claim, and then that's what gives the VA the ability, theoretically, to consider the claim. The reason, if you don't have it in there, they can administratively deny your claim for IU. What that means is that if you later submit it, then they have to treat it as if it were open and pending and re-adjudicate it. So it's kind of one of those no real harm as long as you send the form in. But the reason that they want the form, here's what it all boils down to. On the form, you're providing your income history. And that income history, they're going to bump it against Social Security, they're going to bump it against tax records, they're going to bump it against other federal government records to make sure that you're not spinning a yarn about what your income was. They want to verify that you have a limitation on ability to get a substantially gainful employment because of your service-connected condition, and that's what's on that form. They're going to need that in order to grant TDIU. So to answer the questioner's question, the VA denied it for lack of a form. Is that right? You know, their rules allow them to do it. So anytime that you think you're eligible for TDIU, submit the form. Okay, submit the form. I've got a whole post written about this that goes into a lot more depth as to why you want to file that form, what you want to put on it. I've written a whole book on filing TDIU claims, which you can get on the Veterans Law Blog shop, that will walk you through everything you need to know about extra scheduler, about scheduler IU, how to file it, how to argue it, what evidence you need, what forms to use. All that stuff is in the ebook, and you can go ahead and pick it up on the Veterans Law Blog store. So the second piece of that question, though, is interesting. He said, I know that I filed this form with the VA and they're saying they didn't get it. Well, here's where you get into the dilemma of what does the VA really have? And that's why I tell veterans that the most important claim document that they have is their C file, their claims file. And that the very first thing, anytime you want to try to improve your VA disability claim, make it better, improve the rating, make things go quicker, the very first thing that you have to do is you have to get your C file. You have to get your claims file. Okay, without that file, you're shooting in the dark. You're guessing at what the VA's got. They may be deciding your case based on evidence from another veteran's file. They may have crossed up the files. Happens a lot. They may have not put things in the file that you have proof that you sent into them. It happens a lot. They may have stuff in the file that you don't know that they have in the file that actually cuts against your claim. Okay, so you're going to want to get a copy of that claims file. And we're going to have a webinar here coming up talking about C files, so I don't want to take any thunder away from announcements next week. But I do have a book, an ebook that'll teach you how to get your C file. If it's something that you're interested in, I would encourage you to hold off on buying that book because we're going to update it through the webinar here next week. So in any event, we've got a whole bunch more information about not only how to get that file, but what the heck to do with it. Because a lot of times you get it, and it's 4,000, 5,000, 6,000 pages long. And a lot of veterans are asking, what do I do with all these documents? How do I organize it? How do I use it? How do I take this information and make my VA claim better? And I'm going to do that instruction. I'm going to teach you what we use at my law firm. I'm going to teach you how I've done it for 10 years for hundreds, if not thousands of veterans. I'm going to show you what we use so that you have the ability to go in and make the most out of that C file. But that's the second piece to the questioner's question is if you have submitted your form to the VA and they're saying they don't have it and you're sure that they do, the only way you can prove that they've got it is to have a copy of your C file and say, hey, look, here's a copy of it. You guys sent this to me saying you had it. That's usually the only way that you can prove it. After that, the best thing to do is just send the form in again. In a TDIU claim, your effective date is going to be driven based on facts found when you became unemployable due to that service connected disability, kind of overlapped with when your actual service connection claim was filed. A lot of times it's going to be that form because a lot of veterans do start the TDIU claim by filing that form, but your effective date can go back a lot before that. So if you've got a TDIU decision assigning you an effective date, if it doesn't feel right, talk to an attorney. Have them take a look and see if there's a way to get an earlier effective date. So that's what I've got for today. Looks like we went a good hour and 10 minutes, hour and 12 minutes, so a good discussion here. I would encourage you guys to go to the link that's going to be in the show notes and submit your questions, and I will consider them for the next time around. I'm going to hop on Facebook here after this video ends, and I'll answer a few of your questions in the comments section, and then this video will be available, on our Facebook videos page that you can go back and look at. If somebody once asked me why we don't do this on YouTube, I cross-post the video on YouTube. I just don't do live YouTube videos for a bunch of reasons, mostly because this is the forum that most veterans seem to want. But in any event, you'll find the video there, and then next week we will host this video on the blog itself so that premium members can always have access to it, whether they are on Facebook or not, whether they saw it here or not. I appreciate you guys participating as a thank you for sticking through this long Q&A session with me. I do this every single time. I'm going to give you a coupon code that'll allow you to get a discount. Discount is good through November 23rd. And that coupon code, it'll be in the show notes. And it will give you a 15% discount off of any of the ebook packages that are available on the Veterans Law Blog shop. So we've got 4 packages. We've got the basic VA claims field manual package. We've got a TDIU ebook package. We've got a sleep apnea claims package. And then we've got one package that's all the stuff that I've got, all the books I've written, all the videos that I've done. That's called the Every Veterans Law Blog product package. As you can see, these are real original names that I've come up with, but I'm just trying to be descriptive as to what's in them. This coupon code that'll be in the show notes will give you a 15% discount. If you're a premium member, you also get a 15% discount that you can use on top of this. So your discount as a premium member can always be added to any other discount that we've got. So that'll give you a full 30% off if you're a premium member, which can be a really, really, really good deal on these books. So in any event, thank you all for participating. Y'all have a great weekend. I'm going to go have myself a beer and catch a movie or something tonight. Until next time, y'all have a great day and take care and Godspeed.